Hi everyone, let's talk about the Statute of Frauds. In this chapter, we'll examine the common contracts that have to be in writing under the Statute of Frauds. We'll describe the UCC Statute of Frauds that applies to sale and lease of goods. We'll describe and apply the equitable doctrine of part performance. We'll describe the formality of written contracts. We'll describe and apply the parole evidence rule, and we'll define promissory estoppel and apply this equitable doctrine. So the Statute of Frauds was first passed in England in the 1600s, pretty big deal at the time. The intent behind the law was to prevent fraud by requiring certain types of contracts to be in writing. The intent was to prevent people from fabricating verbal contracts that didn't exist or changing contract terms after they've been agreed upon. So if we require a contract to be in writing, we don't have that verbal contract dispute. This can sometimes backfire by allowing unethical parties to back out of promises they make verbally and don't intend to follow through on. So ethics would dictate that if you make a promise to somebody, you should follow through with that. The Statute of Frauds is going to let some people get out of verbal promises they make if the contract had to be in writing. So the Statute of Frauds for common contracts. There can be a lot of variation when we look state by state, but most states typically require these types of contracts to be in writing. Contracts involving interest in real property, in other words, real estate. Contracts that by their own terms cannot possibly be performed in 1 year. Collateral contracts in which a person promises to answer for the debt or duty of another. Promises made in consideration of marriage, contracts for the sale of goods for $500 or more, or contracts for the lease of goods with payments, total payments, of $1,000 or more. Real estate agents' contracts are typically required to be in writing because real estate contracts are also required to be in writing, and there's a rule called the Equal Dignities Rule that we'll look into a little bit later. Promises to write a will have to be in writing. Contracts to pay debts barred by the statute of limitations or discharged in bankruptcy have to be in writing. Contracts to pay compensation for services rendered in negotiating the purchase of a business have to be in writing. And finally, finder's fee contracts. So real property. We usually just call it real estate, just a common nomenclature. But real property is land, things that are attached to the land, things that are permanently affixed to structures that are on the land. That's real property. So other contracts that transfer an ownership interest in land also have to be in writing. So this is a mortgage agreement, which gives your lender an interest in the real property, basically meaning if you stop paying on the promissory note that you sign, in other words, making your mortgage payment, then the bank has the right to go in and repossess that house to try to sell it and get their money back. A lease is the ability to occupy real property for some specific period of time without actually owning the real property. A life estate gives somebody ownership interest in a piece of real property for their lifetime, and then it's structured that after their lifetime, the real estate will be transferred to some other party. And an easement is the right to use someone else's land without owning or leasing it. This is common perhaps if we had a landlocked parcel where you had to create some way to actually access that land. You might create an easement across somebody else's property, giving you the legal right to cross over their property without owning it to access your own real property. And oftentimes in the modern society we live in, your utilities like electric and gas and water are going to have easements or at least rights of way on your property, giving them the right to come on your property and access those. So the 1 year rule is the one we talked about, where a contract that cannot be performed by its own terms within 1 year. If it's possible that the contract could be performed in less than a year, The contract could be oral and still be enforceable, even if that performance doesn't actually happen in a year. If a short-term contract is extended, and the extension would push the contract term beyond a year, we should probably get in writing, because that would probably then bring in the statute of frauds. In this case, Sawyer versus Mills, which happened in 2009 in Kentucky, we have Sawyer, who is working as a paralegal for Mills. Mills orally promises to pay Sawyer a little bit over $1 million in 107 monthly installments as a bonus resulting from a big class action victory they had. So Mills pays for a while. After paying $165,000, he just stops making payments. Sawyer sues to collect the remainder. Mills motions the court to refuse to enforce the verbal contract, citing the statute of frauds. The court determined that since the contract terms exceeded 1 year, in other words, they couldn't be performed within 1 year, the verbal contract was enforceable. Included in the court's language for their opinion was a quote saying that though it may not seem fair to Sawyer, this is simply the nature of the beast, referring to the statute of frauds. A guarantee contract is where one person agrees to answer for the debts or duties of another. The guarantor would be the person agreeing to pay the debt for the primary debtor. This happens sometimes if you've ever had somebody co-sign a loan, maybe to buy a car for you. This is common when people are young and don't have enough credit to actually go out and get a loan to buy a car, or maybe they're just too young. You might have a parent or some other person in your life who would be willing to co-sign for you. The result of that would basically be that if the primary debtor just stops making payments, the bank could then go after the co-signer or the guarantor to make those payments instead. This just illustrates what that relationship would look like. We have an original contract between a debtor and a creditor. And then we have a guarantor who comes in and agrees to pay the debt if the debtor fails to pay the creditor. Agents' contracts have to be in writing a lot of the times because of the equal dignity rule, which just means that if the underlying contract, so in the example of a real estate contracts have to be in writing. So the equal dignities rule would say that so does the contract between me and my real estate agent. So if the underlying contract has to be written, then we would say the agency contract has to also be written. Promises made in consideration of marriage. Here we're thinking about mostly prenuptial agreements. This is the, when people get together and agree that if, a prenuptial agreement, we get together ahead of time before the marriage actually happens. And we agree that if the marriage ends for specific reasons, then we can divide out who gets what. And these are valid in North Carolina. There are some restrictions put on them. I can't get rid of child support payments under a prenuptial agreement. If I was to divorce my wife and then try to give her nothing, if that resulted in her having to go on public assistance, then the court would step in and make me pay something. But they are valid as long as I'm following the rules. Under the Uniform Commercial Code, which is what the UCC stands for, a contract for the sale of goods valued at $500 or more must be in writing. And for lease contracts, if the total payments are $1,000 or more, it has to be in writing. $500 was a lot more money back in the day when the UCC was originally written. There's been a movement lately to try to get that raised to $5,000 instead of $500, but that hasn't happened yet. So it still stands at $500 for sale of goods. So there are some exceptions to the statute of frauds. And one of those would be an equitable exception, the part performance rule. So basically, if you had an oral contract and people have actually started performing it, then it might just not be possible to return parties to their status quo. And if the court looks and sees that there will be some great inequity if they just don't enforce the contract, they might step in, apply this equitable exception, and partially or fully require the contract to be performed fully. The formality of writing. So under the statute of frauds, the written contract doesn't have to be in any particular form. It can be formal or very informal. It doesn't have to be on any specific type of paper or using any specific type of language, really, as long as it contains the essential terms and as long as the court can discern what should be enforced, then generally the court would do so. The Statute of Frauds and the Uniform Commercial Code require a written contract to be signed. Well, generally, it's a good idea to get the signature of both parties, but the really important signature is the party against whom I'm trying to enforce the contract. As long as their signature is on it, then they have agreed to be bound to that contract, and that's the really important one. But like I said, most of them will have both signatures on there. If somebody thinks that I faked or forged their signature, the victim can hire handwriting experts and use modern technology to prove it is not his or her signature. In the digital age, we're seeing more and more contracts using e-signatures, in which case a similar process would happen if somebody thinks that their e-signature was forged. Then you might have to show that your computer had been accessed or your email had been hacked or something like that. So integration of several writings. This is the combination of several writings to form a single contract. The incorporation can happen by reference, meaning we specifically state it in the contract. One contract refers to and incorporates another document. Or we could have implied integration where I physically attach documents together or place them in the same container. So this could be like stapling documents together or putting them in an envelope together that would indicate that they go together and should be integrated. When it comes to interpreting contract words and terms, if we have not defined them ahead of time in the contract, then we'll follow standards of interpretation, meaning ordinary words are given their usual meaning according to the dictionary. Technical words are given their technical meaning unless some other different meaning is clearly intended. So a lot of times in contracts, the first section of it will be defining the terms to give them specific definitions that will make it easier for us to use them. If that section is not there and if we haven't defined those terms, then the court will go in and say ordinary words are given the meaning that they mean in ordinary society, and which can vary over time, of course. And then technical terms will look at, how is it used in that industry? What is the technical meaning in that industry? To see how to interpret those. So specific terms are presumed to qualify general terms. So if I said oil in one part of the contract and then Brent crude oil in another one, Brent crude oil is much more specific. So then we could go back in the contract and sort of interpret every other instance of oil to mean the Brent crude oil, the specific term. Trade usage is incorporated in the contract unless otherwise stated. Trade usage is how the words are interpreted in that particular trade or that industry. Sometimes we can have multiple different kinds of writing in a contract. So we could have a pre-printed form on which there are spaces for people to type words and also spaces for people to write words. Sometimes you can even have somebody cross out some words and then handwrite over words, other words on top of it. But the basic rule for which words win out is that type words prevail over pre-printed words, handwritten words prevail over pre-printed and typed words, if there is an ambiguity in the contract, it will be resolved against the party who wrote it. So that would be a disincentive for somebody to create an overly ambiguous or vague or just tricky contract to try to deceive people. Parole evidence. Parole evidence is any oral or written words outside the four corners of a written contract. The parole evidence rule is that once the written contract is complete, it is a final statement of the parties' agreement. Any prior or contemporaneous oral or written statements that alter, contradict, or are in addition to the terms of the written contract are inadmissible in court regarding a dispute over the contract. In other words, once we have that writing, we have the written contract there, conversations that we had outside of that contract generally aren't going to be allowed into evidence. There are some exceptions, but that's the general rule. A merger clause, or also known as an integration clause, is a clause in a contract that stipulates that it is the complete integration in the exclusive expression of the parties' agreement. So a merger clause or an integration clause might say something like, the words in this contract are the whole and final agreement, and the agreement can't be modified orally or written by any other party. You know, something that just sort of indicates that this is the final form of the contract and it can't be altered. So we have a case in the matter of Pilgrim's Pride Corporation that happened in the 3rd Federal District in 2013. In this case, Pilgrim's Pride Corporation operates a chicken processing plant in Clinton, Arkansas, and contracts with over 100 chicken growers. Each grower signs a contract with PPC specifying the contractors are renewable on a flock-to-flock basis. Either party can terminate the contract between flocks. There is a merger clause in the contract that states that the written contract supersedes all prior agreements and prevents oral modification of the contract. Later on, citing economic concerns, Pilgrim's Pride Corporation idles the plant and then terminates contracts with growers. The growers sue, citing oral statements from PPC reps that the company was there for the long haul. The issue in the case is, do the contracts signed by the growers bar their claims of oral promises made by Pilgrim's Pride? The court decided that the contracts between Pilgrim's Pride and the growers bar PPC's oral promises because the contracts address the same subject matter as the growers' claims. In other words, the time that Pilgrim's Pride was going to operate the plant. And then the merger clause prevents oral modification of the contract. So even though some Pilgrim's Pride representatives had been telling the growers that they would be there for the long haul and that everything was going to be fine, those words weren't binding on Pilgrim's Pride because we had that written contract that barred oral modification. So the contract said that it operated on a flock-to-flock basis, and then between flocks they canceled all the contracts, so that was it, and the growers were stuck. Like I said, there are some exceptions to the parole evidence rule in which those conversations outside of the contract might be allowed. So those exceptions are if the parole evidence shows that a contract is void or voidable. In other words, if we can prove that there was fraud, duress, undue influence, or a mistake involved, we can allow those outside conversations. If the outside conversations help explain ambiguous language in the contract, if we run across a word or a sentence that we're not really sure what it means, but we can show conversations between the two parties that clearly specified what exactly it means, then that would be allowed. If the conversations concerned a prior course of dealing between the two parties, course of performance between the parties, or some usage of trade that would help us to clarify the language in the contract, then those conversations can be allowed in court. If the conversations help fill in gaps in a contract that allow the court to interpret how exactly to enforce it, that can be allowed. Or if they correct an obvious clerical or typographical error in the contract. So we have a case here, Yard Metals versus New England Patriots Limited Partnership, that happened in 2005 in the Appellate Court of Massachusetts. In this case, we have Yard Metals Incorporated that owned season tickets to the Patriots football games. They allowed a business associate to attend the game. Unfortunately, he was ejected from the game for disorderly conduct. He was ejected for disorderly conduct. Subsequent to that, the Patriots terminated Yard's season ticket privileges in the future. So Yard lost their season tickets. Yard sues, claiming that there was an implied contractual right to purchase season tickets. The Patriots counter that the written contract with season ticket holders states that, quote, purchase of season tickets does not entitle purchaser to renewal in a subsequent year. So the issue here is, does Yard have an implied right to purchase Patriots season tickets? The court here decided that parole evidence is not generally admissible to vary the unambiguous terms of the contract. Yard has articulated no basis on which we can ignore the language on the ticket. So there was no right for them. They didn't have any rights to enforce in the future to buy those season tickets. New England could cancel them whenever they wanted to. So let's talk about promissory estoppel for a little bit. I will have to say ahead of time that the doctrine of promissory estoppel is generally not, the courts generally don't allow it in North Carolina, especially as an affirmative claim. So your chances of enforcing promissory estoppel here are not very good, but in other states you might have a lot better chance at that. But the basic idea behind it is that it allows a court to step in and permit enforcement of an oral contract that should have been in writing if it would help to avoid some injustice. So in order to have a claim, I would have to prove that somebody made a promise that induced some kind of action or forbearance of action by another party. The reliance on the oral promise was foreseeable, and then injustice can be avoided only by enforcing the oral promise. So I made a promise to a person. I was counting on the fact they would rely on it. They did rely on it. And they actually suffered some type of loss. I might be able to say that even though the contract wasn't written, we should still enforce it because it would help avoid this injustice. Again, North Carolina, probably not going to work out, but in other states, maybe. So that wraps up this chapter. I hope you guys have a great one.